All right, welcome to my channel. As you see, this is a small camera for now. No introduction. I'm waiting currently to join in a Zoom meeting with a group in Ontario because they want to hear about the grand jury. So this is what I'm gonna do. So I'm gonna pause the recording until I get admitted into the room. Donc, ça va être une réunion en anglais aujourd'hui. J'attends pour joindre un groupe en Ontario pour parler d'organisation du grand jury. Comme vous voyez, il n'y a pas eu d'introduction, pas de tocsin, rien du tout. Mais c'est ça, ça va être en anglais. Alors, je vous dis à la prochaine fois.
Thank you. You're good? You started the recording? So I'm going to turn off my camera because I'm going to be doing other shit and I don't want you to see my funny faces as I'm thinking about things. This meeting is to get everyone introduced. Again, Paul introduced me to Jeff. And the reason why we're here is because Jeff in 2015 ran a grand jury in Quebec. And so Paul, Jeff, myself had a meeting last week talking about that. And who else? Effie was here too. And oh, you're welcome to share this with Effie, Paul, or actually I can do that right now. I was going to and I forgot. And so I just wanted to bring in some other folks to continue the conversation and so that we can ask more questions about the grand jury that they held in Quebec. So I'm going to let you take it away, Jeff. And I'm going to frozen. Give him a second.
Yeah,
There we go. You're back.
I'm
You're
back.
back.
Thank you. I
Yeah.
said I heard last thing. You're going to let me take it away. All right.
Yeah.
So, grand jury, brief historical background. It was common in Canada at one point. It is a measure of protection for the people against the out of control government. It is legal, lawful, and constitutional. Not only that, but I just said it, it's historical as well, and it was traditional. So all of this backs the grand jury. That being said, the grand jury is also done outside the common legal system. It's done by the people, and you don't need permission from anyone to do it. Generally speaking, a grand jury must be held against the state and not another individual. That would be a waste of resource and time. If you have a claim against another single individual, normally you go in front of a state judge in summary procedure or otherwise, and that's more than enough. When the state is involved, though, that's another matter, because if you go in front of a state judge, well, he's biased to begin with because he's paid by the state. Normally, in criminal justice, the prosecutor is also paid by the state. A lot of time, the witnesses, being cops or otherwise, are also paid by the state. So there's no reason for to even believe that there's a possibility of fair trial. So let's get back to grand jury. Meanwhile, I'm going to try to find the definition, the official definition in the Black's Law Dictionary. But the very first step of a grand jury is this. Anyone can read that? It may be upside down for you. I don't know because.
Yeah, the Constitution Act, 1867 to
All right.
1902.
So
Yeah.
this
The
is.
BNA Act.
Yeah, but this one is not the BNA Act, to be honest. This is the Ottawa version, and it's completely
Yeah.
different than this is the real deal.
The UK version. Yep.
That's the UK version. It's this thick, both sides, and this one is that thick because it's been modified at all. Yeah, every corner of it, both side again. So it's best to use this one. It's much easier. Another just small background about the grand jury. It comes from the Magna Carta Libertatum. Sorry for my Latin. It has over 800 years of existence. They've tried in England everything they could to repeal the Magna Carta. It failed at each time they've tried that. It's still in effect today. Now, in the Magna Carta, the word grand jury are not there, but what you find in there is basically the freedom to put your government on the stand for trial. And it was refined over the period of 800 years. So to me, it's a very strong foundation, and it's been used and abandoned in most common law jurisdiction, including Canada. Only the United States are using it today, and they're using it to make a criminal investigation most of the time in order to lay criminal charge. But in Canada, historically, it was mainly used in civilian matter and not criminal matter. The other thing too that was forgotten, but it's clearly stated in Trial by Jury by Lysander Spooner, that any jury, whether it's a petty jury or a grand jury, has the power that is called jury nullification. In other words, law nullification. If a law isn't just by nature, the jury can nullify the law no matter if it went through Parliament, the Senate, and whoever. Even if it got a royal assent, they can nullify the law, and that's the bottom line. Then there's no trial. Um, all right, so I'm gonna jump into what happened in 2015. First, the grand jury itself is just a little older than that because I've discovered it in 2013. Then I made my research. We started procedure in 2014, to be honest. But just to resume it, this grand jury in particular, it basically lived and died in 2015. All that remains today is the judgment that comes from it. It's very powerful. People are still using it today. All of that being said, I don't think it'll be a miracle measure that you can use if you choose to do one. In fact, I'm pretty certain that the power that ought not to be are going to basically ignore it. But if you base your grand jury on the one that has been done in 2015, they've never said we could not do that, and we've achieved a lots of result. I'm not here today to speak about the result. I think you're more interested in the organization. So like I said, this is the foundation, Constitution of Canada. This is what you need to defend upmost, including in your procedure of grand jury. That grand jury that you are going to organize, if you do so, has got to go side by side by the criminal code. If you notice that there is a criminal act or of any nature, you just write it down on a side note, and you can lay charge at the end of it. A grand jury, like I said, by nature is not a criminal court. So there will need to be a second procedure, whether it's before a petty jury or a summary procedure, from the order that the prosecutor will receive from the grand jury. I'm going to quickly look. Grand jury, there's one entry. It says, actually, there's two entries. It says the first one, page 699 of 6th edition of Black Law Dictionary, says see jury, and the second one, grand jury investigation conducted by a grand jury into possible wrongdoing. Generally, such are conducted under the aegis of the prosecuting official, and they may or may not result in indictment. And see jury again. I'm not going to go read jury. It's easy. A jury is basically a judge, so they can write a judgment. So they're using their power of self-government and judgment to show a case. All right, so back to the history. The very first thing, if you want to take note about that, I've got no problems. And if you need me to slow down, I will, or repeat, I will as well. Very first thing was to realize the power of a grand jury. And let me be honest with you, to this day, even though I've organized and successfully held one, I don't fully understand the extent of the power. It's much more powerful than I can imagine, and I have a strong imagination. So the very first step is to, well, I'm going to use the word victim, is to actually find a victim, but I prefer to call it an instigator. But you can take it as a victim, someone that will be closely tied to your grand jury and that must appear in front of your hearing. Um, and I'm gonna come later to why I'm saying that. So this person is gonna be your key witness. He knows everything about the case you feel like prosecuting. and he's going to provide the strongest support to the judgment, let's say. Second thing is and this is not necessary, but I advise for it. So the instigator can be fully concentrated on his testimony. I advise that you select a prosecutor which will be representing um, the victim or the instigator. So this person or human, and I'm not talking about the legal person here, this human, this prosecutor can focus on organizing the grand jury and also conducting the hearing. Um, so basically, you're building a team. Now you can have more than one witness, of course. And I would suggest as well that you get more than one prosecutor. And once again, it's tied into what I said a moment ago. I'm going to come back to that. Um, After you find those two, the third step that I've put forward was to organize a committee of the court composed of three people: the prosecutor or the main prosecutor, a president, and I'm not too sure how you call it in English, but it would be a court official that would be recording the minutes and organizing the paperwork. I've never been in court officially in English, or you can call that a court secretary, I guess, if you've got a better terminology for that. I'm all willing to hear about it, but there's always one in any court. Usually they type on a little machine there, or they simply record. And so this committee will oversee the organization. It's not an easy process to organize a grand jury. It took, in 2015, to be honest, it took a year before, from the moment we took the decision to form the committee to get the juror and to actually proceed with the hearing. Hopefully, if you already have a group of people, I was alone, so that's why it took so long. But if you do have a group, it may very well go much faster than that. So hopefully, that's going to be your case. Now, the job of this committee, outside of organizing the hearing, what we did in 2015, we wrote a constitution for the grand jury, not for the country or a corporation. There was 7 drafts of it. It started with 1 or 2 pages, and then it ended up being 64 pages. Basically, this is the framework of the grand jury. Where are going to be the hearing, the time of the hearing, are we going to hear witness, are we going to summon defendant, all that stuff. By the way, the grand jury do have the power to issue summon, but I wouldn't bet my shirt on it that the defender will show up. And if they don't, basically it's good for you because you can still stand trial and they're absentee. So they're not there to defend themselves, so you can hammer even more. Another key factor is that you use an actual law, whether in the Constitution or elsewhere, which is supposedly valid in Canada. And that's the way we've done it in 2015. We didn't accuse people per se. We The defendant was a law. So, the law doesn't defend itself too well. It cannot speak. So, and it worked. So, if you could do the same and not hope and waste time in trying to summon people you know in advance that they will not show up, well, you may as well speed up your procedure by that much. So
So like if we run into like summons as in like the people that we want to um appear in court as defendants.
Yeah,
you can
basically.
summon everyone you want, but like I said, I wouldn't hope that they will show up. Besides, you have no way of enforcing if they don't
Yeah.
show up. So yeah, we did summon people. They didn't show up. We were happy about that. It was okay with us because, like I said, who was in the accused or defendant seat? It was the law. So it was easy, to do it in that regard, and nobody felt threatened by the grand jury. As if you're summoning or accusing a person with the grand jury procedure, they may feel threatened. So it's gonna cut the stress by a lot if you do it this way. You had a question. I'm sorry, I didn't get your name, Mr. Natural Law NB.
No, it's okay. I was just gonna make a comment, but I'm good.
Okay.
And it's Ivan.
Ivan. All right. I'm not too good with name. I will try to remember.
Okay.
Sorry if I don't. All right. Where was I? Okay. So 7th draft of the Constitution. During the same time, we had preliminary hearing on the similar case. Our case was against the Worker Compensation Board, as I said in my previous recording. So it was easy to find other victim. And each one of them either prosecuted or represented themselves in front of the grand jury, or they had a representation. Oh, which makes me think that in order to represent in front of the grand jury, you don't need a law degree of any kind. Anybody can represent in Latin. They say, I think, in propria persona. And they can still get an hearing without having any degree of any kind. So in all, we had 7 cases that were put in front of the grand jury. 5 directly related to actually 4 directly related to the Worker Compensation Board claim, and 3 supporting claim. One of the claim was against the legal mortgage. The second one was against the, and this is because it happened in Quebec, that will be in French, I don't know the translation, against Fédération des producteurs de sirop d'érable du Québec, so Maple Syrup Producer Federation, something like that as a translation. And the third and most important case that was not related directly was a constitutional case. Someone came at the grand jury, presented the Constitution, and showed evidence that there was a problem. Like I said, I'm not going to extend too much on the result that we've achieved. I'm here to talk mainly about how to organize it. So while you are writing the draft of the Constitution, I suggest you start taking application for people who are interested in being the juror.
Jane, I think you're trying to speak, but you're cutting out.
Oh, okay. I didn't.
We're good?
Okay, sorry.
All right. So while you are writing the draft and organizing thing as for the hearing, start taking application for the potential juror. You need 23 in a grand jury. And I strongly advise that you also draft a few more, just in case people are chosen and they don't show up. So this way you have backup and your procedure doesn't fall flat because you're missing 1 or 2 jurors.
I do want to chime in here, specifically on jurors. So what we're working to do here in New Brunswick is get enough people that are comfortable going into the courts to participate and see what's going on, and basically making sure there's enough educated people to know and I think like what we're doing basically right now is we're trying to get people who are confident enough to speak on others' behalves in order to find out who would be a willful juror, essentially, because someone who is willfully going to speak up for another is probably someone who you would want to have on a grand jury, because they're actually going to be like Rebecca and Jane and yourself and whatever, like the people who are actually being active in the law are the ones that you're probably going to get to participate in these things, and keeping a roster of those people. So I don't know if you guys are doing that like in Quebec or whatever, but that's kind of like what we're doing here. We're trying to get people associated together as far as the law is concerned to make sure that everyone knows who's who, and that like who's willing to be volunteer juries. If, for instance, we walk into court and we have a jury notice present, there's no need to subpoena anyone to come in and even be witness in a court if you have willful participants from either the public or whatever the case may be. So I just want to kind of bring that up.
Thank you. Or was I? Oh yeah, juror. In a grand jury procedure, unlike a petty jury in criminal court, the jury itself is allowed and also encouraged to ask question to the prosecutor as well as the witness or the instigator. One other piece of advice about the instigator, I think it's important when you draft your constitution that you put one of the key article in your constitution that the grand jury cannot be dissociated with the instigator. That means if this person is ruled out of the grand jury, it will collapse on itself. I had to do that because my friend's case was so heavy that I had to present it last, and it was there was a chance at the time that we run out of time during our procedure. So in order to make sure that this case got heard, it was tightly knit with the grand jury. If that case was not heard, the grand jury was null and void. So it kind of put an obligation on the jury to come back to hear that case. And that said case, the most important one, I also advise that you present it last. So if you've got side case and supporting case, you present them first. So this is going to assure that the case you want to be heard is going to be heard. Prosecutor, you can name them as you wish. And as an example, I was the main prosecutor of the people, and everyone else, we had 6 other cases else than the one I was presenting, were assistant prosecutor of the people. It it's just a title. It doesn't matter much. Same thing for your court committee. It's just a title. It doesn't mean much. But people like that. They feel it's reassuring to have titles, so you can use them. What we did about the grand jury, about the 23 juror, all in all, we had, if I remember correctly, we had 59 applications. So of course, some people are too much. We don't need them to be in the waiting room just in case. So we've provided them with a draft. Very simple. We assign every name a number. We wrote these number on a piece of paper, put all these paper into a hat, and we draw a number. So this way, you're not actually choosing who's gonna sit. It's really a draw, so nobody will be disappointed, and nobody is in fact favor. So it's one human, one chance. That's and the more people apply to be a juror, well, the less chance you in fact get to be chosen. It's a heavy duty to be a juror. It's a big decision. It's a lot of weight. It's stressful. So yeah, maybe people are gonna be interested in the procedure without being chosen. So that should bring you some public awareness. The more people join in to be a juror, well, those people at the end, they're mainly not going to run away. They're going to be there as spectator. So that's good for you. Then,
Witness.
well,
No witnesses now.
no, they cannot be in conflict of interest. If you've got a potential
I mean,
witness,
for the grand jury itself.
he's got
For
to
the
stay
grand
as a
jury.
witness.
Yeah, for the grand jury itself.
Oh,
That
yes, yes. Good call. Yes, they're going to be witness of the grand jury, but they're not going to be witness at the
Yes.
grand jury. Yes, I get that. Um, so after that, we got preliminary hearing. And everything happens during the same year. We started hearing some case. I think we had in total for the worker compensation board, we got 10 application for case. So we took the strongest one. We took out of 9 others, because remember my friend's case was really tight to the grand jury, and the other one we said, well, sorry, we can't take everyone. And but the result, even though we don't hear your personal story, is going to be good for you, and you can still take the judgment and at the end and use it for yourself. And that did happen. We had a surprise at the grand jury. One of them case that the committee chose not to hear still showed up at the grand jury, and he was ready to go, that gentleman, and he asked permission in front of the court during the hearing, would you please hear my case? I have 45 minutes that I need, and that's it. And they said yes. So all of us, we went to get coffee or sit in the the seats at the back, and the gentleman presented it itself. So in other words, be ready for surprise, because the court is by its own right, so it decide what it wants to do. Once the grand jury is in hearing, the power is in the hand of the juror. So they may decide, no, we don't want to hear this witness, or yes, we want to hear an extra witness. We're going to issue a subpoena. It's for them to decide. So that's why you keep your court committee, because if the jury decides something, well, it's up to the court committee to execute this decision. The jury will not do it itself. Then you proceed with the hearing. Be ready for long hours. So that's why I suggest you do that in person, in a room that you've selected before. Like I was saying during the other recording, can be a church basement, can be a school gymnasium, can be someone's living room, which I don't suggest. I strongly advise that it be a public space of some kind. Now, not open to the public though. It is by nature a grand jury. It should be done behind closed door. You don't need to accept any public. What you need to do is record the hearing. That's something else, so that at the end you can show that you really done it. But public access is absolutely not necessary. In our case, we rent a meeting hall in a hotel, and we did keep the door open for anyone to come in. There's not many that showed up, but there was still some spectators. Then you proceed with the hearing. This can be organized as you see fit, the order of the day. You hear the witness. You start by reading the act of accusation. That's the first thing to do. Then you hear your witness, and then the jury, once all is said and done, that's a few words, but it's the big part. And the prosecutor are free to write the judgment, especially if there was a default on the part of the defendant. In fact, it is highly suggested that each prosecutor write is part of the judgment. Then the court committee put everything into a bundle. Then you go back in front of the jury by itself. You read them the judgment. If it's appropriate, they're going to accept it as is. If not, they are still free to make some change to the judgment. And that's how it's done, even in the regular court today. If there's a default, the prosecutor will write the judgment, will submit in front of the judge. If everything's in order, there will not be a single line that will be changed, but he's still free to review it and can change something in it. If the prosecutor doesn't write a line, then it's all up to the judge to write the judgment. So that can be done, and then the fun begins, because now you've got a valid judgment in front of the court of the people. It's the strongest instance there is. There is no court above the court of the people in common law. But like I said, will the defendant hear about it? Because they're so used of not being accountable, there's a little chance that this will happen. But remember, your target is not really the defendant. The target is the rest of the people, everybody that will not show up at the grand jury. This is your real target. So you're there to educate yourself and them, and then to distribute the judgment, and it will be up to the people individually to choose to carry it or not. And that's how it happened for us in 2015. We did achieve direct result with us, because we're people carrying the judgment to the defendant, but we're still achieving result today because other people heard about that grand jury, and they're printing their own version of the judgment, and they're carrying it everywhere. And I can swear about that, that the so-called government of Quebec and elsewhere, they really hate the grand jury, but none of them to this day, including 28,000 lawyers and a few hundred judge and a few hundred corrupted politician, nobody said a word against the grand jury, especially not, oh, you cannot hold a grand jury, it's not valid. They didn't say that. The only thing they can do is gain time by ignoring it. That's exactly what they're doing. But it's okay with us because it's the only defense that we've left them on purpose. Ignore it all you want. The grand jury was real. It's now reaching, it will be on the 15th of June of this year. It'll be reaching its 8th anniversary. And it's growing stronger by the day because more people are getting aware and they're carrying everywhere. So I, on a weekly basis, get report, oh, they're ignoring the grand jury. Well, good, because that's the only defense that they have against it. But it's the power of the people that you're carrying in the end. And yeah, then you have a grand jury. And you're free after that to proceed from the order that you've received from the people. And that's where it's very strong, because if you're a prosecutor like I was at the grand jury, what I'm doing today, and believe me or trust me, because I don't ask you to believe, I gain a lot of power from the grand jury, and I'm still carrying this power today. And so people, frustrated, egotistical people are coming against me. Or you're trying to impose your rule. I got a judgment of the people. I'm acting on behalf of the people. So are you contesting that these people, the 23 courageous jurors at the grand jury, have no voice, have no power of self-government? And that shuts them right away. They cannot argue against that because they're going against the will of the people. And yeah, then they disappear. I've seen a lot of people come and attack me personally, and everything fell. And I'm still here to this day, carrying the grand jury on my back, high and strong. And I got a mandate of the people to solve the actual situation in which Canada is. And like I said, I'm not going to extend on the result, but we're still working on it. So much so that the 6th of May of the year 2023, upcoming in a month, you may not see it because we don't really have a public voice on Facebook and other, except my small YouTube channel, but we're going to form the first de jure government of and by the people for as long as man had a memory. So there's going to be a legal sitting government for the province of Quebec for the first time since the corporate coup d'etat in 1968, and it's happening in just over a month from now. So those are the results we've achieved, and there's way more. Paul was there in 2019 he could speak to you about, but we've talked with Paul yesterday, I think it was, and it's not time to blow your head with all that we have done. You're at the grand jury phase and level. I very much support that you do one. Even if you don't follow all of my advice, remember a grand jury is informal. So feel free to modify it a little bit. The important factor is prosecute a law or an official. Go by the Constitution. You need 23 juror, and the prosecutor does not need to have a diploma or a degree of any kind. And you're good to go. You don't need to form a committee. You don't need to write a constitution. You don't need to hold a draw. But these, is all part of the organization to show the other people that you are serious about it. And because it was the very first grand jury in a long time in Canada, well, I felt kind of obligated to go through these extra procedure. Oh, and the cherry on the Sunday, our grand jury in 2015 was an authentic act before a notary public. It was not necessary, but we were able to find a notary public to be our witness not of anything, of any activity of the grand jury, except that, yes, these guys have in law or in witness held the grand jury. So he's there. He has nothing to do with what happened at the grand jury, but he was well aware that it did happen. If I can grab the grand jury's judgments, you have every page, there's a stamp by our notary public, but it's not necessary. And the last thing for the judgment, it's simple majority, not consensus. So the moment out of 23 that you get 12, you have the majority, you've got your judgment. The other are not necessary. It's good if you have a consensus, but a simple majority will enable the judgment to be in effect. So that's good enough. Another detail precisely for our grand jury, most jurors were there in person. One or two were there by camera because they live so far. The province of Quebec is a huge place, so some people could not really make it for every weekend. But if their numerical signature was on the judgment, we may not need a pen. It was good enough unless they contested, and no one contested it. So in our case, we got a consensus. So yes, if they cannot show up for the reading of the judgment, it's good enough to have their signature by just writing it down. That's something you must keep in mind to write on the judgment. If you're not present and your signature is not there on the judgment, your name will be used as if you were there. So in under half an hour, because we took 5 minutes at the beginning, I think that sums it up, and I'm ready to thank you very much for listening to what I had to say. And if you have any question, if you want the
Thank
answer
you.
about the outcome, go watch my YouTube
Yes.
channel. Everything's there, but everything about the procedure that I can answer, I
Okay.
will.
Okay, great. Jane and Ivan, do you guys have any points or questions that you'd like to address?
This new government, is it gonna be under the Constitution?
Yes, sir.
Like Government of Quebec under?
Yes, sir.
Yeah?
Yes, sir. Because
Okay.
we've noticed major problem with this version. Major problem, especially from Article 71 to 80.
Sorry,
There's
major problem with what document? Sorry, which is that?
this document, Article 71. I'll just read you 71, all right? Just that one.
That's the Canadian version, right?
Yes, yes, yes. And you may not like this, but it's not valid. All right. So here's what happened. Page 21. That's one of the results we've achieved. All right. And these articles were not repealed. They're still printed in this version, so they're valid. Article 71. There shall be a legislature for Quebec consisting of the Lieutenant Governor and two Houses, styled the Legislative Council of Quebec and the Legislative Assembly of Quebec. And here's what happened. In December 1968, the 31st of December to be precise, they've enacted a law which disbanded the Legislative Assembly to replace it by the National Assembly and officially disbanded the Legislative Council. Well, that's the Constitution. That's the supreme law, and anything which is not, how they say that, that is not reflecting what's
Not
written there.
consistent,
That's it. Not consistent
not
with the
consistent.
yeah, to the extent of the provision. So basically, this
Yep.
article and thank you very much. So that shows you know it. So this one up to 80. So that's 9 articles. Are totally ignored by the National Assembly of Quebec, making it a de facto government, a corporation, to be honest, and they're illegal, unlawful, unconstitutional. So basically, they're traitors. And that was trialed at the 2015 grand jury. So following that, me and other prosecutor got an order from the people to solve the situation as best as we can. And the de jure government of and by the people forming next week is a direct result of that. So that's why I said to you, Rebecca, at the beginning that I'm not fighting anymore. I've won the fight and I've passed the result or the torch to other people to make the peace We're there at this point. We're not at war with the National Assembly. We're doing the exact thing that they're doing of us. They've been ignoring the people for 54 years, and now they're getting a taste at their own medicine. We're ignoring them. We're forming the government of and by the people. And when I say we, I'm not part of it. So much so that I'm 5,000 kilometers away from Quebec, and I don't care what happens there. I've not lived there since 2004, and I have no intent of going back ever. So they can do what they want. I have no stake in the outcome, but it's absolutely historical to see a government of and by the people, and they all
So
sworn
you were
allegiance.
able to participate as prosecutor in 2015
Yes,
when you
yes.
were not
No, I
a
was there.
resident?
I was there in propria persona because for some reason I had to go there, even though I was not a resident or a citizen of Quebec. I was there physically. So yes, and I was there for a few years, but I've never changed my address back. I never felt like I lived there. I only rented a house for some years, and I was there. That's it. But no,
So if grand jury in Ottawa, someone can uh, locate here for that purpose.
well, yes, you got to remember that justice is distributed on a provincial level. So your prosecutor and witness and victim or instigator can come from wherever. But it's important that the juror reside in the province in which you're holding the hearing. On that, I will advise
Why,
first.
why would that be? Because courts are federal jurisdiction and they're federally regulated. The
The,
province is only administer, and if you're
that's
dealing
yeah, exactly because
with
of
our
that reason. Exactly
federal
because that.
government
So
and
when
it's a jury, I don't see why it can't have members from other provinces, and especially when it's conducted in Ottawa, which is the capital city.
Yeah, but
I
Ottawa's
don't see it.
Ontario, and Ontario has the jurisdiction of the court, so that's why if you go in front
No,
of their
no,
court
they
right
don't.
now,
No, they don't. They do not have the jurisdiction of the courts. They have a bastard court. They have the Ontario Court of Justice, which isn't even constitutional. But the Superior Court of Justice and the Appeal Court, and the Supreme Court, all are federal jurisdiction,
yeah,
exclusively federal. The only thing the provinces have, and it spells it out, is they can administer, but the regulations and the responsibility, the jurisdiction is federal for all courts. And I
yes,
don't want that to change. I like that. I want to get rid of the Ontario Court of Justice because if you even look at the name of it, there's such a thing as a UN Court of Justice. And this fucking piece of shit came about in 1989, right on the heels of free trade, a bastard court. And these judges don't have the inherent authority under common law. They only have the authority under statute. So the government can change their authority and control them in complete detail. And now they're starting to throw criminal charges through there, but the judges don't even have the jurisdiction to deal with the issues that arise, such as bail. Fucking bail. They can't. They have judges prosecuting, and they can't even deal with the fucking bail, and they can't deal with property that's been apprehended in relation to the charge, and a bunch of other fucking shit. I don't even think they have jurisdiction to do the rights, like the Canadian Bill of Rights, because it doesn't spell it out in their statute. It's an inherent right of the
yeah,
of
I get you and
yeah,
about the UN court and the yeah, I fully get you. But if we look at article, and that's why I suggested you go by the BNA Act. If we look at Article 91 dash 27,
27.
it says the
Yeah, I know
criminal
it.
law except the constitution of court of criminal jurisdiction, but including the procedure in criminal matter. And then you tie
Yeah,
this up to powers of the province, 92,
yes.
14
And
and
for
15, administration of justice in the province. So that's why. And
yeah,
if you look at their court right now,
right,
the way if you go in front of a petty jury,
the
everybody's from Ontario.
yeah, the matter is federal regulation. So the fact of having a jury is a common law for one thing, and it's a federal the courts and the jurisdiction of the courts and the judges themselves and so on is federal. So the jury would be federal, and the administration of it would be provincial.
Well,
So if
you are free to
this
do as you see fit,
no,
but like I
not-
said, if you abide
have
by
a
the Constitution to begin with, nobody can come back at you. Because if you don't, well, then they're gonna say, look, the administration of justice is on a provincial level, and this is a court that you've been having.
but don't you know the difference between regulation and
Well,
jurisdiction and administration?
yes, I know the thing, but
A clerk administers under the supervision and regulation. So they're not the end all be all. They don't make the rules. They just carry out the process. So they can do things like they can create a physical space. They can hire the clerks. They can whatever. But the judges are federal that are in there, and they're federally regulated, and the whole court process itself is federally regulated, and especially for criminal, that's criminal code is regulating it. That's federal, not provincial.
yeah, I'm
And a
aware.
jury
I'm aware of
is
that.
in
You're
right to a
honestly,
jury
honest.
in the criminal code. Criminal code. Juries are in the criminal code.
Yes, honestly,
So that's federal.
you're speaking to a choir here. I'm all with you on your side, but this is a matter that you see your committee can discuss in between them, because I will not be part of your grand jury in any way, shape, or form. So the way you're going to establish, you do it as you see fit. And not trying to convince me, because it will not change anything. I mean, I cannot change a thing to the grand jury that was held in 2015. But historically, when there
Yeah.
was grand jury in the province of Quebec, there would be all people from Quebec. If there was a grand jury in New Brunswick, there will all be people of New Brunswick. Now, you do as you
Those
see
issues
fit.
were provincial issues. So your issue was the workers' comp. Our issue is treason, and it's treason of the federal government under the criminal code, which is federal.
Yeah, but then
And the judges
you're using the wrong instance.
court.
The grand jury does
Eh?
not do criminal court. They can do an
Yes, it does.
investigation. No, it don't.
No,
It
it
does.
doesn't do the court.
It
I'm not
doesn't
saying
lay
it does the court.
charge. So that's why I'm saying
Right.
Yes,
that.
we know that. It doesn't lay charge. We understand that. I totally get that. Totally understand that.
Yeah. But it's still criminal matters that they're relating to.
So you cannot initiate your grand jury by accusing someone of treason. But if you do put the criminal code in the seat, I mean, then you get all attitude of accusing the criminal code of not being respected, or even better, if you're putting the Constitution into the seat. Oh, and by the way, which makes me think that I've had a little chat with Paul, even though with Paul it's never really a little chat, it lasts for an hour when I speak with him. I suggest you do as you see fit. But because I'm speaking of the Constitution, there's one very interesting article. Remember, I told you earlier that we had side case. So we had a main case, Worker Compensation Board, another case. Here's one that maybe in fact I got two suggestions for you. That would be Article 91.5, Postal Service. It may seem weird, just like that. If you don't know, Canada Post was sold. It's now a private corporation. Their employee are not public employee. But I would advise and suggest that as a side case, you put that matter, which will bring you the Constitution by default. Now you have a law which will be in the seat. Remember, we're not trying, or you can put Canada Post if you want, but it's best to do the law. And here's the second one, which I think that you may get a ton of traction, much more than the Postal Service. The Bank of Canada. You were talking about treason. Well, these guys, because they're not acting with the real mandate that was given by the people, and they're putting their corporate private bankster friend, the government now borrows with
Yeah.
interest instead of going with the Bank of Canada interest free. That would bring a lot of attention to your grand jury, because now you're talking about money, and there's not a single one person in Canada that can say I'm not involved with anything that relates to money. We all are touched by that. We're all affected by the issue of money. So side case, if you would, the Bank of Canada would be a strong case that would work in your favor and get a lot of traction. Now, that law is not, unfortunately, part of the Constitution because the creation of the Bank of Canada came in later. But if to bring the Constitution, the Postal Service would be perfect for you.
I think bank is in the list too.
Um,
I think
it may
in the
be,
list of
well, it may be in
federal
this version, but remember, this is not valid. Unfortunately, the charter is not valid. Any modification.
We know that.
So-
We know that. You're
So-
talking, we're on the same page with this.
All right.
Yeah.
I already mentioned to him about the Bank of Canada thing that I was trying to do before all the scamdemic started. You were, you knew about that as well, that I was working on that. But, you know, scamdemic due to the flu, everybody didn't care about that shit. They wanted to deal with the flu shit. So that's why I kind of put that on a back burner and just wait till see what fucking goes on.
Yeah.
If you
Guys,
allow,
I'm kind of running, I'm really sorry, but I'm running out of time, on my end. I don't know if you guys are okay to continue, I could just let this run. If you guys want to chat more, I'm totally okay with that.
well, if you'd allow me 3
Me?
more minutes,
Yeah,
and then then
I'm just gonna turn off my video.
all right.
You
So
guys go for it.
all right, page 855 of Black's Law Dictionary again. I've flipped the page to grand jury.
Sorry, what version of Black's Law was that?
6th edition.
Okay.
okay, good.
Grand jury, a jury of inquiry who are summoned and returned by the sheriff to each session, and whose duty is to receive complaint and accusation in criminal case, hear the evidence adduced on the part of the state, and find bill of indictment in case where they are satisfied at trial ought to be had. So that tells you that yes, they can hear about the evidence, but they need to move it to another instance. That's why I suggested that you open your criminal code, and each time you take notice of a criminal act, you in fact write a bill of indictment. They are first sworn and instructed by the court, i.e. the committee or the prosecutor. This is called a grand jury because it comprises of a greater number of jurors than ordinary trial jury or petty jury. At common law, a grand jury consisted of not less than 12 nor more than 23 men. Body of citizens, the number of whom varied from state to state, whose duty consists in determining whether probable cause exists that a crime has been committed and whether an indictment or true bill should be returned against one for such crime. If the grand jury determines that probable cause does not exist, it returns a no bill, and it is an accusatory body, and its function does not include the determination of guilt. But remember, Black's Law also covered the United States, which call themselves common law. It's something else, it's a corporation. They mainly do exactly what we said there, and the only one who are still using grand jury to this day. In Canada, it is historical that the grand jury was mainly there to put back the government into the framework and decide other things where the government would not do. It can be about anything, but it's mainly in civilian matter. Is there anything else? It switched then to hung jury and partial jury, so I'm not going to read that. There's federal grand jury, but not sure. Maybe you're right, Jane, there about that, and that's what you could do. Call it the federal grand jury and do as you said earlier. I mean, like I said, you're free to enact the grand jury as you see fit, as long as you respect the basic of it. Mainly, it's
Yes,
23
yeah.
people.
Okay. So if we convene this, or know when we convene this, would you be interested in sitting on it
No,
as prosecutor?
no, I've done one grand jury. I'm still carrying it to
That
this
was a
day.
big fat no.
No. No, because I know what it involves. I've received lots of flack for the 2015 grand jury, much more than one normal man can handle. They hate me to death in Quebec because of that. And like I said, there's 28,000 lawyer that hates me. There's a few hundred judge that hates me. 24 more Sûreté du Québec, which is the so-called provincial police. A whole bunch of people hate me for it.
Our
Oh,
CMP has no great love for you either, do they?
who?
Hey, there's
Our
nothing wrong with having criminals hate you.
I know about
Well,
that, but it took a
yeah.
toll on me, and I've done the fight, and I've passed on to other people to establish the peace. Um,
Well, how about this?
And if
How about this, Jeff? I get that you don't want to be in the public spotlight or you don't want to be like participate publicly. But if we have any questions on the back end, and if you have any questions that we,
Advisor?
yeah, would
Oh,
you be?
yes, I could be advisory
Okay.
board to your court committee for, and I'm not promising anything, but
Yeah, no.
I could review your constitution of the grand jury process. But like I said, I'm not committing. I support wholeheartedly that you organize a grand jury, and I also support that you do it free of me. Because I've organized one, because some way I'm already part of triggering a second one, even if it's, from the sideline. You probably be
Well,
best
all of us,
without me, because if I'm going down,
yeah,
I'll drag two grand jury with me, and it'd be best that I'm not there. Advisory, I don't mind. I mean, it's
yeah.
easy. I've told
Well,
you all I knew.
Paul's the one that initiated this, so I'm assuming it was inspired by your work.
Well, yeah.
Well, I did not invent grand jury. It does not belong to me. I've simply brought it back from,
it's
from the
everyone's.
attics and put it on
The
public
garbage. They
space.
tossed it in the garbage. We pulled it out of the garbage bin.
Yeah,
That's where we
yeah.
found it. Really.
That's where the Bill of Rights was.
I know. But we're pulling shit out of the garbage and polishing it up so we could
Yeah.
use it nice.
Yeah,
And-
exactly.
And getting people acquainted to it, the stuff that could help us here.
Yeah. So I
So
didn't have the time to be on the jury as
I know
I-
Ivan's got some
as
feedback.
organizer,
Yeah,
prosecutor.
well, I also come up with the idea if you
Yes.
need like impartial jurors, people that don't have any stake in the outcome or whatever.
Yeah.
Retired
The-
auto workers, or there's an army of those around here that we
Yeah.
could use.
Sorry, I couldn't hear. Retire who? Sorry, would you care to repeat?
Retired auto workers.
Oh yeah. Well, yes.
Over here, you
Um,
got retired auto workers from Chrysler, Fords, and GM that are, thousands of them.
excuse me, guys, just one second. Okay, so I only budgeted a half hour for this call, so I'm just going to be
Yes.
very brief.
Okay.
Okay, so this is absolutely what needs to be done. So this is exactly what I was thinking when I started getting into the law, that it's about people. Has been done. And I like the thing that you mentioned about having a notary present with the people, because to me, what that would allow to happen is I like the idea of there's a level of validity to me
Right.
that
Exactly.
that there's these bridging concepts between how things are done and the way things need to be done. And I think having notaries involved, or people who would willing to fill that role, will allow people to have like admissible evidence, admissible sworn testimony that can be then transferred into some sort of a judgment or summary judgment, even in a civil matter. I'm just saying it on that grounds, like transferring it from a community based judgment into something that is like actually acknowledged by civil court.
Yeah.
Right.
And
Yes. This-
Another way to do it would be
Yeah.
to is like all the people that are going to be there that are not jurors, they could do lives on Facebook.
yeah,
That's another
it's
way to
public
make it.
public awareness and involvement.
That's
Yeah.
right. Because we
Yeah.
need critical mass looking at this.
Yeah.
shit.
Yes.
So guys, I actually I need to leave now. But if you guys want to have another meeting sometime or whatever, I'm definitely open to that. But I kind of had plans.
Yeah, no, Ivan, listen, you listen, I asked you last minute. Thank you so much. Get out of here. Appreciate it. You're awesome. Love you. Go.
Love you all. Thank you for coming together.
Peace
And if
out, bro.
someone if
Adios,
someone can send
amigo.
me,
What's that?
if someone can send me the link to the recording, because
Yeah.
I'd like to watch it over with Eric and Kim and obviously my people.
Okay, and Ivan, before you go, super quick question. Janice, the one that got fucked over in the court, the provincial court,
Right.
yeah,
Yeah.
she's having a hard time with the appeal. Tara's helping her, but Tara's not quite there in terms of helping her and isn't asking for help, which is frustrating. Bless Tara's heart. And they're not sure how to appeal, where it goes to. She's reading 30 days and 25 days. I know it's typically 30. I think she's looking at Supreme Court, not like, I don't think she goes to Supreme Court. So any insight you could give, because she's kind of
This is
panicking.
Nova Scotia, right?
Yeah.
Well, it was a provincial, isn't it?
Yeah. Oh my gosh, she literally just messaged me.
It should be. Yeah, it should. It should. There should be. Oh my God! It shouldn't be that hard. There should be just like an appeal form on the court website.
You know,
Or-
and you would think like we struggle with BC too, right? But anyway, I don't want to hijack this, but I'll look around. But if you know anyone who knows, let me know, because I can't just go somewhere and find it, and that's
I'll take a look, but I'm
okay.
It's the weekend, and I
Yeah,
was
no,
in
I
Portland for 2
understand.
days.
Go.
Just
Bye.
letting
I'm
you
gonna kick
know.
you out if you don't leave. Go. Bye.
Okay, love you
Yeah.
all.
Thank you. Okay, bye.
Bye.
I'd like to read a quick definition, and that's why I can kick their bottom part so hard, because I know it's true. The judge that you're going against or in front of right now, whether it's British Columbia, Alberta, it doesn't matter, Quebec or Ontario or New Brunswick, it's all the same. They're called judge de facto, and the definition from the Black Law is simple, 5 lines. One who holds and exercises the office of a judge under the color of lawful authority and by title valid on its face, though he has not full right to the office, as where he was appointed under an unconstitutional status or statute, sorry for destroying this word, or by an usurper of the appointing power, or has not taken the oath of office. And in Quebec, it is so real that last time that I was in front of their stupid court, I literally said that they were judge de facto, and they agree with me. And when I said I'm going to arrest you right now for treason, they backed up. And I was only convicted of stuff that I agree with to begin with, because that thing against the Worker Compensation Board, like I said, they really hate me for that, so much so that I was dragged into a court, and I knew it was a procedure to shut me up, and in order for me to be prevented by them to show up in any office. They've got 27 office or such a number in Quebec of the Worker Compensation Board, physical office that you can walk to, and I was making a mess of each and every office, and so they wouldn't know next week which office I would pop to. So they and because, like I said earlier, I'm not a citizen of Quebec nor a resident, I didn't care to promise that I would never show up again, because everything was said and done. And by that point, my friend had his case resolved by them. So they were really afraid of that. So I promised never to show up in one particular office, but in fact, it was all of them. And they found me guilty of exactly that. And they convicted me, you never to show up in the Worker Compensation Board office. I say, all right, fuck you, I'm gone. So that's it. They're judge de facto. That's why you cannot get remedy in front of them. Justice is not possible when they pretend that they're lawful when they're not. And lawful to me is not so important. Constitutional is much more important because that's really the frame of the government. And I'm happy that you're triggering a new grand jury. I will be even more happy and joyful when it's all said and done. You have a task on your hand.
Yeah, I'm not going to be happy until Trudeau, Freeland, Lametti, Blair, and Mendocino are behind bars.
Well, there's more to that, right? If you're
Yeah,
to
well,
proceed on,
we're
if
gonna start with them. We're
well,
gonna start with them. Then
it-
we're going after every last fucking bastard that helped them out with their bullshit.
well, I was about to say that, and I suggest that you also call, even if they're dead, you call Father Trudeau, he's dead, but you call Jean
Oh, God,
Chrétien,
yeah.
call Mulroney, call
Oh,
Harper, call Martin.
Father Trudeau, right there.
Yeah. Oh, I got a long grievances against
Yeah.
that fucker.
Yeah.
The
Oh, yeah.
charter.
So yeah, don't limit yourself to the actual sitting and living. Yeah, call them out for what they are. And I agree with you wholeheartedly. Sorry, Rebecca, when you said the other day, parties are a big problem. Holy crap! I
Yeah.
was happy to hear that.
Oh, yeah, absolutely.
And you
Yeah,
know what? The Constitution doesn't have parties.
I know,
And
and it doesn't have the
Right.
title of
when
prime
you
minister.
when, and
Yeah.
when you
Yeah,
Or
yeah.
when you
years.
run in Canada, you run as an individual, not as a
Exactly,
party.
I support
In
that.
the United States,
Amen. Look,
yeah.
look.
In a more
I
direct democracy.
Yeah,
You got a salute, James.
yeah, I raise my hat to that, and but
More
one,
direct
okay,
democracy than we got.
I know
We need-
everyone's on a timer. Sorry for interrupting, Paul. But this is probably my only visit to your group, so I
Okay.
wanna express that we've achieved result that would blow your head after the grand jury. I don't want to speak him too much. Paul is there as a witness to vow for what I'm saying on how far we went. Um,
I met his friend, the one he defended.
So,
Denis?
yeah, Denny, exactly. So you know what happened in 2019 at the convention in Falcon Lake. You know everything that we've done. So I
Yeah.
don't want to spook you, but it's there. It has happened. We are very, with this, the result of this grand jury, we're very far ahead to what you're doing. Um,
Yes.
but
Yeah.
I still support the fact that you will do your grand jury. I wish that it be a common measure brought back, so whenever the government's out of control, people instantly think of grand jury, and not it being an exception. I prefer it to be the rule. So yeah, do it, do it quick. We need you. Your country, which has been destroyed
Yeah.
to rubble, needs you, and the world will see this event as an historical fact. You may never get a statue
Yeah.
at your name, but you'll still be a
Mag-
hero.
We can
I'll
we
just
can
tear
make
it
we can
down,
make an
you know,
ice
I'll tear
sculpture.
it down.
This is going to be the Magna Carta 2.0.
Yeah, yeah. Okay, guys, I gotta run.
Okay.
Jeff, thank you so much for your time. Paul, Jane, thank you very much.
Yeah. Good
Okay,
night.
we'll
Thank you
we'll
for
talk
your
See you at
soon.
time.
8 o'clock tonight.
This will be up
Yeah.
on my YouTube channel in a few minutes, in a few hours, and you can watch it there. Thank you very much.
Thank
I'm
you.
stopping the recording.